Welcome, everyone, to the National Center for Technology and Dispute Resolution's first ODR student panel for the events this 2023. My name is Leah Wing. I'm the director of the center, and I'm going to be the moderator today. We have an amazing panel with not only students of ODR, but young professionals who are also contributing theory and practice to the field. And so I don't want to take any more time to introduce them, other than to point out that you can find their bios on the program agenda. And we will have today Cemre, Kadioglu, Kumtepe, Mubarak, Nurudeen, and Adria, Medina, Altarriba. And I want to welcome all three of you and begin with Cemre.
Thank you so much for the introduction and giving me the floor. I'm really, really excited to be here, to be honest. I'm going to talk about my PhD research a little bit, and it's about blockchain dispute resolution and specifically about due process. So, but when I'm saying blockchain dispute resolution, what I mean is not specifically blockchain disputes or disputes arising out of the use of blockchain, but rather online dispute resolution platforms that are using two specific technologies called blockchain and smart contracts. I don't really want to go in detail like what these technologies do, but I do want to talk about a little bit of the keywords that surround these technologies. Blockchain is actually the underlying technology that of crypto assets, NFTs, metaverses, and it is actually a distributed ledger. Its users are generally anonymous or pseudonymous that are scattered across the world, and they run this network. And it is decentralized, meaning that the technology does not really need a central authority, such as a state, agency, or any other intermediary to validate, confirm, or enforce the transactions. But smart contracts does actually, they are their pieces of code, and they work on an if-then basis. And if a condition occurs, they automate the outcome. So for our purposes, for dispute resolution, together with blockchain, smart contracts actually help automating the outcome and executing it on chain without requiring any additional step. As I said, there has been some platforms that are using these technologies to resolve disputes. And when they first emerged, they said that they're going to address traditional contracts, disputes arising out of traditional contracts, arising out of smart contracts, or any other online dispute. And these could be legal, but at the same time could be technical, such as issues due to bugs in a code, for instance. And some of those are available to a larger community, but some of them are only for users of their own services, similar to eBay, for instance. Instead of e-commerce, it's open only to blockchain transactions or crypto transactions that are happening already on their platform. So they're also offering different types of procedures. And if we group them into two, some of them are consensual and the others are educative. What I mean by consensual is that these procedures are being used to facilitate negotiation among the parties, or mediation or settlement, or parties go and ask about their dispute to get like a majority view to see which party's hand is actually at a better position, kind of leverage their positions, to be honest. Or they're using these procedures for mock trial, or get like a sense how a jury would decide during court litigation. Educative procedures, on the other hand, are used to decide the case for the parties. And I was able to identify two main procedures that I can call as educative. The first one is blockchain arbitration. The other one is crowdsourced voting, which is generally misrepresented or misconceptualized as arbitration for quite some time. By blockchain arbitration, I mean a type of facilitated arbitration. Some platforms like EOS arbitration or Ethereum, they refer to ancestral model law, ancestral arbitration rules, or GEMS arbitration, or United Kingdom jurisdictional task forces, digital dispute resolution rules. What they describe is exactly an arbitration procedure, but sometimes the award is executed on chain, on the blockchain, or some of them are referring to New York Convention enforcement. And we do not really see it happening just yet. Majority of those are at the design stage, or they remained at like an idea on the white papers of the platforms when they first came up with this procedures. But we know that they are referring to already existing arbitration rules. The other one, crowdsourced voting, is like people come up with a legal or technical question. It is generally a yes or no question, and the jurors, these are anonymous people, they use their crypto assets such as tokens or cryptocurrencies to stake to be selected as jurors, and they try to vote with the majority. And if they vote with the majority, they get an award, they are rewarded. And what they do, they select either yes or no. And if majority says, for instance, yes, and then they get a reward. This is basically conceptualized, as I said, an arbitration, but as we know, it's not an arbitration in the very traditional sense. The outcome then automatically executes on blockchain. So what happens is that parties do not really have a say in their descriptions, like to go to a court, for instance, or have a judicial redress, unlikely to UDRP, for instance, enforcement mechanism. Therefore, like I am particularly focusing on educative mechanisms and how due process actually relates to those procedures. And it's difficult to define and interpret due process for those specific procedures because there aren't any rules just yet. But what I like, there are also different interpretations and applications of due process. There is like substantive due process, which relates to outcome, like whether the outcome is fair or not. And procedural due process, which also divides into two, subjective due process, that is how the parties perceive the procedure, and also objective due process. That's like from an objective, reasonable person standard, whether the process is fair or not. And I'm interested in the objective due process more specifically. And the sources also relate to determining the processes, because I defined the educative processes as blockchain arbitration and crowdsourced voting. I am working with ADR and ODR principles, but at the same time, I'm looking into European Convention of Human Rights and the decisions as relates to arbitration and alternative dispute resolution, and if it happens, online dispute resolution. And I must say that while looking into different due process rights, they're non-exhaustive. People can say that let's include this right, this element into due process, and let's exclude this for BDR. And I'm keeping that in mind as well. So that the important bit is like, why should we care about due process in BDR? It is such an informal, out-of-court, private mechanism. Well, there are a few reasons for that. As I said, I'm looking into European Convention of Human Rights and courts' decisions as well. And it says that electronic justice is like, and should be subject to the rules on access to court and right to a fair trial. So by just saying that it's a quasi-judicial or out-of-court procedure, you cannot really relieve yourself from due process rights. And also, as I said, there's certain blockchain arbitration platforms or mechanisms describing New York Convention enforcement, which at the end of the day, if you're going to go to a court, you need to think about minimum due process requirements under the convention. And if the parties or the platform opt for automatic execution, this might actually give you a closed circuit mechanism, which is something quite nice. You don't really have to deal with the courts, but at the same time, you need to get the trust, as we discuss all the time with the ODR. And the parties would trust the system if they think that it's fair. And since most of the time they're not going to get a redress, it is useful to have certain minimum requirements of fairness embedded in the technology. And as again, it could be a good solution in the future for other ODR processes, because we're discussing that enforceability is a huge issue, and introducing certain level of due process would also helpful for that regard as well. Okay, due process is good, due process is relevant, but how are we going to ensure that in BDR? I suggest that we embed the rights and start thinking about their designs. And in my research, I also try to come up with a checklist of minimum requirements of due process for the platforms, and at the same time, like public authorities to go through and apply the due process in their designs. By answering certain questions, the platforms can actually check whether they are doing a good job by embedding due process guarantees or not. I'm also developing a quantitative scale to measure their compliance with the due process guarantees. And this can also be used by the public authorities. Again, this is important in the future to be used by the authorities to integrate with the system, which I will discuss at the very end, because I believe that these mechanisms, blockchain dispute resolution platforms, can actually be embedded within our current dispute resolution systems. And what do I think about the current stage of the BDR? I've been looking into 24 different platforms which existed or kind of deprecated, but appeared as an idea. Unfortunately, not a lot of them are in operation right now. I don't know the reason. They kind of retracted their applications, or they remained only as an idea. Some of them are at the design stage. We see that platforms are operating on some end, but they're still developing the dispute resolution layers. Only a tiny bit of them are in operation, and one of them is the very famous one. I think when you type in blockchain dispute resolution, it pops up. It's Kleros, and that's the only one that's in operation. And what I see is that there are not yet many users or many use cases that we can go ahead and largely analyze how they're dealing with the cases, whether any fairness issues really we can see within those cases. So when I applied my checklist to these platforms, whether they're in operation or not, based on their descriptions alone, and apply the scale, I realized that majority of them are actually in medium compliance. So this is actually a good news, because this means that they're not at the they are not failing the scale, which can happen in my scale. They're not at low compliance, but they're at the medium level. What is striking the most is the voluntary participation and informed consent that can be obtained from the parties. It is really lacking on those platforms, because what I see is that the platforms cannot really inform the parties about their procedural rights, what they can waive, what they cannot, and how the outcome is going to affect them, whether the decision will be binding on them, can they, to what extent they can determine the process, or is it a already determined procedure? This is not informed to the parties, and which is really, really important, because the platforms did not really fail on the other aspects that much, but this was the most important one. And when I like have a broader general overview, I realized that there are technical and legal safeguards that can be implemented easily. So we should not discard the idea of BDR, but we can like think about how we can actually employ these safeguards to enable minimum due process requirements. And I do see a huge potential in BDR following the European Union digitalization, especially from the Digital Services Act front, because it has like it requires digital service platforms to attach an online dispute resolution platform. And I think BDR could really complement that. Cybersecurity NIS2 directive calls for cryptographic or blockchain-based applications for highly important critical entities. And I think arbitration, when it relates to certain sectors, could be among that. So maybe arbitration institutions can think about implementing blockchain dispute resolution, as well as like I think proposed Data Act is also relevant for that one. So this is just my last slide. As I said, I think BDR has a huge potential and it can really be integrated within our system. And by using the checklist and the quantitative scale, I think the public authorities can actually enable the accreditation of BDR bodies as well. And at this point, maybe blockchain users or like the blockchain arguments could say that this is a decentralized mechanism, which means that we do not want the states, we do not want any regulators. But what I see is that we are really past at that point because we see states regulating every aspect of blockchain and crypto asset, NFTs, and like so. Dispute resolution, which is the, I think, most important applications of blockchain as a judicial mechanism, should not be disregarded in that front. And what I'm just suggesting, only the base minimum. And I'm also considering cost and time efficiency. So not too much formality, but at the same time, some kind of fairness embedded within the system. So when these regulations are happening, I think it should be considered that there is a tight connection with crypto assets, smart contracts, and blockchain regulations. And also like some jurisdictions like the UK decided that crypto asset users should be considered as consumers. So this is something that we will see. Consumer protections should be also considered while developing certain guidelines. Thank you so much for listening. I hope I didn't really overstep my time.
Thank you so much. Cemre, really appreciate that presentation, very stimulating. And so many of us don't have a lot of familiarity with blockchain, or even if we do, we might not have thought about it a lot regarding ODR and especially cross-jurisdictional dispute resolution. So I just want to give us 2-3 minutes for any questions. Feel free to raise your hand or put a comment in the chat if you'd like. Adria, please.
All right, Cemre, that was an amazing presentation. And I see so many similarities with what I will be presenting about. And you talked about the new Data Act by the European Union, which is really exciting. I'm going to be talking about data sharing in terms of user evaluation. So one of the things that struck me was what you commented on the platforms failing at giving informed consent to the users, right? So sorry about my voice, I'm feeling a little bit sick. So then what is your findings, or what is your opinion on how to break it down? Because you have a very specific target user here, right? You have someone who apparently knows about blockchain, but there are also many users who might be more vulnerable in this sense. They just, a friend of mine recommended investing in this crypto asset, right? So I did it, and then now I cannot bring it to another wallet. So what I'm gonna do if I don't really know the system, even I myself, I honestly can say that I have zero idea about how the technicality behind it works. So how do you break it down? I don't know if
Yeah, this was
if there's
really
a question there or not.
Yeah, this was a really difficult task because these are not regular users or visitors of a website. These are consenting to a dispute resolution process, which I like. It's not even mediation or like a negotiation. It's like an arbitration or educative ADR, which comes with formal requirements as well that are very well like we have very well established arbitration standards or ADR standards when it comes to education, and these include like not only formal but also substantive, like the capacity of the users, for instance, from a substantive perspective. But on the other hand, if this is going to be like a New York Convention type of arbitration, you need to have a written agreement. What constitutes in writing when it comes to smart contracts. There was a lot of unpacking, and I don't think we have like a sufficient time to answer all this. But like, what I think it's suffice to say that now smart legal contracts, the smart contracts that are embedding legal ideas, are being considered equal to traditional contracts by a majority of law institutions or like guidelines or reports. So that's how I actually approach like whether this technology can satisfy the requirement of law under the law, formal validity or substantive validity. If no, why? If yes, why? Kind of situation. And I do think that it does, like if you think about all the safeguards available at this point in time, we can say that it is like it does satisfy the validity requirements as long as they implement the points in the checklist. But I must say that this also depends on the jurisdiction, because not all crypto or smart contracts are legal in all jurisdictions. So it's really highly dependent on the local law as well.
Right.
Thank you very
Right,
much.
then.
Sorry.
Mhm.
Did you want to say
No, I
something?
just wanted to. I think this is the key, right? It's the complexity of total integration of the different substantive rules, right? But then, have you considered there's Directive 2014/37 on abusive contract clauses in the European Union, and this is actually proud Spanish jurisprudence sent to the Court of Justice of the European Union, which states that for a judge to oversee an abusive contract, an abusive clause, to determine whether it's abusive or not, it has to have a abusive technical look at it. So it has to pass two controls. First control, abusive in itself, and second control is transparency test, whether the person that goes to the bank, asks for a mortgage, has really understood that their insane indexed interest with the Japanese yen is something that he really wants to do, right? Because this was something that was happening a lot here in Spain in the late 2000s. So I don't know if you have considered that the two different tests, especially the transparency one, to address this issue, right? Of
to be honest, I'm not referring to that particular instrument, but transparency is definitely one of the requirements under my criteria. Yes.
Thank you.
Great.
So much more to talk about and unpack. And for me, this just shows the richness of listening to students and researchers on the work that they're doing. So close to the ground on new laws coming out, proposed legislation, and innovation. So thank you for starting us off. And our next speaker will be Mubarak.
Yeah, thank you so much. Just a moment to share my screen. Okay, yeah. Can you see my screen?
Yes, we can.
Okay, good. Yeah, good afternoon, everyone. It's indeed a pleasure to be here this afternoon to discuss metaverse with you. But before I delve into my presentation, I think I would want us to look at this video for the next 2 minutes. Can you all see my screen, please?
Not the video, Mubarak.
Okay, just a moment. Apologies, I guess I'm having some problems with my Chrome at the moment, so probably I'll have to skip the video. Yeah, so let's get into the presentation. So I'll be discussing metaverse, the harmony in the virtual world, analyzing the prospect of dispute resolution for effective conflict resolution and governance in the metaverse. So the growth of technology in recent years has been quite fast-paced, and the pace is actually expected to continue given the fact that the development of one technology stimulates the creation of another. And at the heart of this technological development in recent years is the fact that we've had people move gradually from physical interaction to virtual interactions. And at the heart of this virtual interaction is where the metaverse comes into play, because it is actually a form of virtual interaction. But at the heart of all this is the fact that the series of interactions in the metaverse brings about a lot of disputes. And as dispute resolution practitioners, we begin to ask ourselves about the sufficiency of the extant legal framework or the sufficiency of our traditional court system to provide the remedy that aggrieved persons who are probably or whose rights have probably been violated within the metaverse space. Because we have a lot of interactions in the metaverse, and there's a whole lot of traction in the metaverse in recent years. And in fact, a recent survey about the metaverse has predicted that the metaverse economy is actually going to boom to about $5 trillion in the year 2030, which is about or equivalent to the economy of Japan. So this series of interactions within the space calls for a lot of concern on the part of dispute resolution practitioners about the sufficiency of the extant legal framework. So now, but before we proceed, let us conceptualize some concepts that are key to this presentation. So I have the avatar, the virtual reality, online dispute resolution, and the metaverse. So the avatar is basically a graphic representation of a user within the metaverse space. So I like to link or perhaps situate the relationship that exists between an avatar and a user to that which exists between a company and a director. So it's basically a sort of alter ego relationship. So the avatar is basically that person or the representation of the particular user within the space. So a user on the metaverse space can actually design its avatar to look exactly like him. And then we have virtual reality, of course, which is basically a computer-generated simulation. And then ODR, of course, we know what ODR means, the use of technology in the resolution of disputes. And of course, metaverse as well, which is an electronic environment where users can interact with other users or perhaps computer-generated environment. Now, let us take a brief look at the historical background and growth of the metaverse. Of course, the metaverse is not new, but the modern day metaverse or the use of the word metaverse can actually be traced to a science fiction writer, Neil Stephenson, in his book Snow Crash in the year 1982, when he talked about metaverse. But prior to then, of course, we've had a number of writers actually talk about things that are a bit related to the metaverse. And of course, in 1838, we had Sir Charles Whitson, where he outlined the concept of binocular vision, where you combined two images. Also, we have in 1935 the work of the American science fiction writer Stanley Weyburn, which he published book Pygmalion Spectacles, in which the main character explores a fictional world using a pair of goggles. Now, so that is basically an historical background of the metaverse. So in essence, the metaverse is not new, and it's been around for a while. Now, the question that we begin to ask ourselves is, why exactly should this metaverse concern lawyers and dispute resolution practitioners. And of course, like I said earlier, there are a lot of series of interactions, or there are series of interactions within the metaverse space. People transact businesses in the metaverse. Brands are opening stores in the metaverse. Nike, for instance, has a store in the metaverse. Adidas has a store in the metaverse. So people invest their cryptos in the metaverse. They purchase things in the metaverse because users, through their avatars, buy things in the metaverse. And now the question that we begin to ask ourselves again is, how are disputes that arise in the metaverse going to be resolved? Are our laws capable of providing remedy to a person whose rights has been aggrieved in the metaverse? Do our judges possess the requisite technological expertise and know-how to be able to adjudicate in this kind of dispute? So that is where we as dispute resolution practitioners come in, and that is exactly why the series of interaction in the metaverse should concern us as dispute resolution practitioners, because as we would see in the later part of my presentation, that disputes such as intellectual property, labor claims, breach of contract are the category of disputes that are likely to ensue as a result of the interactions within the space. So the future of the metaverse and the new species of disputes. And I usually say that just as the internet has brought about new species of disputes, so too will the metaverse bring about different species of disputes, because the series of interactions in the metaverse is capable of bringing about the disputes that exist in the real world to find their analogs in the metaverse. And I tried to compartmentalize the category of disputes that are likely to ensue from the interactions in the metaverse to three. And I call them the disputes against metaverse platforms, the disputes against amongst the metaverse users, and of course the dispute against or what I call inter-metaverse disputes, one metaverse suing another metaverse dispute. Now, how can a dispute against the metaverse platform exist? And I give you an instance. For instance, you purchase a landed property within the metaverse space, and after a week, that metaverse space decides to, or perhaps goes bankrupt, so and dissolves. So, what remedy do you have against such metaverse space after investing a lot of cryptos into buying that asset within the metaverse space? Or perhaps dispute amongst metaverse users. Another metaverse user or a user on the metaverse platform has used your trademarked logo. So what remedy do you have against such another user? Or perhaps can our conventional courts provide the remedy that you need? And of course, the third one, inter-metaverse disputes, that a platform or a metaverse platform can actually sue another metaverse platform. And we can also have that kind of dispute in cases of breach of intellectual property. But in all of this, one question still stands unanswered, that how will disputes in the metaverse be resolved? And what mechanism is well suited for the resolution of these particular kinds of disputes? Now, the point here is that at the moment, the metaverse space is not completely ungoverned. We have certain framework that governs the activity or regulates the interaction within the metaverse space. And some of those legal frameworks, we have the TOS agreement, that is the Terms of Service Agreement, the Community Standard Agreement, and of course the EULs, the End User License Agreement. All these are frameworks that currently regulate the interactions within the metaverse space. But the question that we ask ourselves is, to what extent can this legal framework provide the remedy that the person whose rights on the space has been violated needs? Because sometimes the remedy that these legal frameworks provide are usually not sufficient. For instance, an avatar within a space has suffered damage as a result of the activity of another avatar. And is it just going to be sufficient to say we are blocking the user from the metaverse space? Because that user sometimes, or a user sometimes, has perhaps suffered a lot of injury that blocking another user alone cannot sufficiently remediate. So the issue here is that these legal frameworks are usually not sufficient. And in fact, most often than not, again, the remedies they provide are basically to protect the owners of the platform. They do not really protect the users on the platform. So I would argue that these current legal frameworks are not sufficient. Now, let us take a brief look at some of the recent litigations within the virtual domain. We had Mubarak and Lindenlab. So this is basically a dispute between a Pennsylvania attorney and Lindenlab, where he sued the Lindenlab for criminal conversion and breach of trust, because he basically purchased a landed property within the Linde Lab space, and Linde Lab dissolved subsequently. So he basically sued them for criminal conversion and breach of contract. And of course, we have also Nike and StockX, which is basically a dispute between Nike and StockX in relation to use of marks and logos within the metaverse space. But in all of this, it is not really about the fact that we have these disputes, but the fact that we are already having disputes ensue within the metaverse space show potential for a lot of disputes. And this would put into question the sufficiency of our extant legal framework that we currently have at the moment. How far can this traditional court system provide remedy or succor to a person whose right has been violated within the metaverse space? Now, when faced with a metaverse-related dispute, any dispute resolution practitioner is necessarily faced with certain questions. The first question would probably be, how can the aggrieved person ventilate his grievance? How can this person get remedy for the violation of his rights? And of course, after determining that, you talk about, or you look at the issue of jurisdiction. What court will have jurisdiction over these disputes that has ensued? Is it because sometimes many of these disputes that arise on the metaverse space are actually trans-border disputes that involves one user in one jurisdiction, another user in another jurisdiction. For instance, a user in the United States of America has an avatar within the metaverse space, and that avatar has offended or has perhaps violated the right of another avatar whose user is actually located in Nigeria. So what court is going to have jurisdiction over this kind of dispute? Is it going to be the United States court or that particular court in Nigeria? And of course, the applicable law that applies in the context. So is it going to be the United States law or the Nigerian law that would apply to this category of dispute? And of course, the issue of whether or not the traditional courts or perhaps the judges have the requisite expertise to adjudicate in this kind of disputes, because most times these disputes would actually require evidence that are contained in blockchains. So do our courts actually have the equipment to analyze this kind of classified evidence that parties will tender before the court? So these are questions that arise when an attorney or perhaps a dispute resolution practitioner is faced with a metaverse dispute. And lastly, of course, we have the issue of enforceability of any judgment that will come out from adjudication using our traditional court system, because basically any judgment that cannot be enforced is useless. So parties are actually concerned about the enforceability of their judgments. Now, let us also talk about the legal impediment to the resolution of the dispute within the metaverse space using our conventional court system. And like I already talked about, jurisdiction remains one fundamental issue that our courts will grapple with when faced with resolution of dispute within the metaverse space. Of course, courts will ask themselves, what court will have jurisdiction over this issue? Do I necessarily have the subject matter jurisdiction over this issue, or do I have the territorial jurisdiction over this issue, or are the parties those who I have jurisdiction over them? Because like I said earlier, these disputes can involve parties in different jurisdictions. So do the courts have jurisdiction over some of these parties? And the applicable laws as well. Courts would tend to grapple with the issue of applicable law. What corpus of law will apply to this category of dispute? And the expertise of judges as well. The judges possess the technological know-how and expertise to adjudicate in this kind of dispute, because most often than not, these judges are basically or basically perhaps have knowledge over the regular kind of dispute. They do not really have technological know-how to adjudicate in this kind of dispute. And of course, the fluidity of online identities. Are we able, or can we say our courts have jurisdiction over avatars? Because these avatars are actually not persons. They are basically representations of their users within the metaverse space. So can our courts assume jurisdiction over these avatars? And again, another issue that people would grapple with would say that, okay, can we lift the veil of these avatars and perhaps go after their users? Of course, all these are still subject to test, and literatures are developing in this regard. The enforcement of the judgment. So, like I said earlier, the enforcement of the judgment is another basic or fundamental issue that any person whose right has been agreed within the metaverse space would grapple with. How do I necessarily enforce these judgments that I've gotten from the courts? Now, ODR to the rescue. You would see that all these identified legal problems are actually resolved by ODR. Alternative dispute resolution actually provides that leverage that could be used by the person whose rights have been violated in the metaverse space. Because with ODR, the issue of jurisdiction will not be an issue. With ODR, the issue of expertise will not be an issue. With ODR, the issue of flexibility and convenience will not be an issue. And in fact, with the ODR, the issue of fluidity of the online identities will not be an issue. So ODR actually provides that needed platform to provide remedy for persons whose rights have been violated within the metaverse space. So I am saying, or I am arguing, that ODR actually contains that needed mechanism for the resolution of the category of disputes that are bound to ensue from the series of interactions within the metaverse space. Because ODR, we have jurisdiction is resolved, it can give binding decisions, and of course, expertise, because ODR would ensure that persons who are saddled with the adjudication of this kind of disputes are people who have the necessary skills for the particular dispute that is at hand. Now, recommendations on how to leverage ODR for effective conflict resolution in the metaverse. And of course, my first recommendation would be a novel-based dispute resolution model. And this novel-based dispute resolution model is actually two-pronged, a two-pronged approach, I would say. The first is establishing the metaverse courts, where we are going to appoint metaverse judges and magistrates to adjudicate on the disputes that are bound to ensue from the interactions in the space. And of course, arbitration as well. So it's going to do a two-pronged approach where parties can actually explore something similar to our conventional courts and arbitration as well, but they are going to be solely based online, and all the entire proceedings will also be conducted online. And before we can do this, we actually need to have an international treaty addressing the disputes within the virtual domain. So this international treaty will be signed by parties. States or countries will become state parties to this international treaty. And this international treaty would actually take care of certain things. Three things I would say. The first one being the jurisdiction to prescribe, that is, enact laws that would govern or regulate the interactions within the metaverse space. Because like I said earlier, all the legal frameworks that we have at the moment within the space are not sufficient or are not enough to provide the needed remedy to persons whose rights has been violated within the space. And of course, after jurisdiction to prescribe, that same treaty would confer on these metaverse courts the jurisdiction to adjudicate on the disputes that are ensuing or perhaps coming up within the space. And of course, the third being the jurisdiction to enforce, being that these judgments that will be given by the metaverse court will be capable of being enforced in every part of the world. So when states or countries become state parties to this international treaty, any judgment that is given or handed down by a metaverse court will be capable of being enforced against any party or any user on the platform in any other country of the world who is a state party to the treaty. Now, the last one would be the absolute autonomy and territorial sovereignty for the metaverse. So we're basically going to recognize the metaverse space as an entity different from the real world. It's going to be completely different. And of course, scholars have argued in this regard that the metaverse needs to actually have an entity or be recognized as a sovereign entity on its own, such that it is going to have its own laws, its own courts, and enforcement proceedings within the space that will be different from the real world proceedings. Conclusion. So I conclude by saying there is no denying that the metaverse is a new, bright, shiny object on the horizon, and it is fun to think about where it will lead us. But as dispute system designers and dispute resolvers, we need to prioritize the need of disputants in any discussion about exciting technologies like the metaverse. It may be exciting to play with these innovations and marvel at their richness and power, but if they are of no demonstrable value in helping parties find quick and effective resolution of their disputes, we should set them aside. We need to leverage what we know about the psychological needs of disputants and the neuroscience of disputes to inform us about the true utility of these new tools. If we get wrapped up in idealism about the potential of these new technologies, we may lose sight of our core task, helping people find fair and effective solutions to disputes. Therefore, as dispute system designers and ODR specialists, we have a unique opportunity to be the primary force in setting up a dispute resolution system for the virtual world. the failure of the ODR community to involve itself in the growing debate among legal scholars as to how to regulate and govern the virtual world would represent not only a missed opportunity, but also a tragic abdication of responsibility in contributing the experience that we have gathered over the year in improving dispute resolution in the real world to the development of a conflict management system in this new virtual space. Thank you very much for listening.
Thank you very much, Mubarak. I really appreciate that. And if you let us have the screen back, I'll thank you. We'll give it to Adria. You could see we're just bursting with ideas coming from young scholars, and really appreciate your contributions. With that in mind, I invite people. I'm aware that the formal session ends in about 11 minutes, but anyone who could stay longer, that would be fabulous, so we could take a couple questions and hear a full presentation by Adria. Mubarak, I guess, Adria, can you wait 1 second just so he can get at least one question in? I guess, let me just see if there's someone in the audience that has a question. Otherwise, if you can give a very brief answer. Wonderful. Cemre, go ahead, please.
If somebody else doesn't have any questions, I'm really curious about certain things, especially your, I love everything about your presentation. It was really, really eye-opening. I'm just worried about the very last bit, like your recommendation as to international treaty, because I'm just curious about how it is any different than New York Convention or the Hague Conventions that are already facilitating those decisions. And also treaty making is such a difficult process. Even sometimes appointing a chair to the session is a hurdle. How are you going to bring all those states to agree on this? Especially some of them are actually banning the use of these technologies. Some of them are actually making them crypto assets, some of them making their own countries fiat money, while some of them are banning it. And also enforcement, isn't it rather than a legal issue, more like a technical issue when it comes to this blockchain and metaverse things? You can have an enforceability decision or enforcement decision, but how you're going to actually alter the code or transfer the passport from one to another, isn't it that the main issue? Does your international treaty has a solution for that one? Thanks.
Thank you very much for the question. Yeah, regarding the first bit of your question on the posture of states to the adoption of technology and things like that. Yeah, that's part of one of the essence of this ODR forum, or perhaps the National Center for Technology and Dispute Resolution. We need to actually bring about measures, or perhaps put in place things that would ensure that states actually key into some of these things. So there needs to be a sort of movement, or perhaps enlightenment on our part as dispute resolution practitioners, to ensure that people see the importance of creating a new legal framework, or perhaps a new or entirely different dispute resolution mechanism for the metaverse that is different from the extant courts that we have at the moment. And regarding your question about the treaty, like I said, the treaty is going to cater for three things: the jurisdiction to prescribe, the jurisdiction to adjudicate, and the jurisdiction to enforce. So when we already have state parties to this treaty, the issue of enforceability can actually take place in any of the countries within the state party to the treaty. So the enforceability would really not be an issue, because when they are signing that treaty, or when they become signatories to the treaty, they are basically accepting all that comes with. So the issue of enforceability would be things that the treaty would take care of. And of course, the issue of prescription, because it confers jurisdiction on the metaverse court. So they are basically accepting all that comes with it. So it's really beyond just signing the treaty. They are accepting all that comes with it as well.
Thank you. Great question. And I know that there are other questions there. Let me ask if folks won't mind if we save questions for any of the three panelists for after Adria goes. So let me hand it to Adria. Thank you.
Thank you, Leah. Can you confirm that you see my page?
Yes.
All right. Still, you can see it.
Yes, we can. Yes.
Perfect. All right. So, hello everyone from Prague. It's 5 minutes and it will be 11 p.m. here in the night. I basically would like for you to get the idea of how data can change how we see ODR platforms grow and get implemented. And so what I've been doing for the past months in Prague here, I am interning at PRK under the direction of Zbigniew Klupel, and we are in a EC-funded project called ODR Scheme. Basically, what we're trying to do is to set up a series of rules and code identifiers for cross-domain data exchange for the future, data sharing between e-justice systems and systems from other areas than justice, right? And here, as you can see, this is obviously on the way. So it's nothing definitive. It's not a numerus clausus, but the main idea would be that if we have a standardized way of processing, gathering, and sharing the data between platforms, we will be able to then index it. And once we have it indexed, we can set up an assessment. And once we assess, we can give out ratings, right? So the idea, again, it's on the making. So feel free to then critique it, comment it. That would be greatly appreciated. The idea would be to have a base, an ODR evaluation portal, where on the one side we would have a certification system. Here we're talking about core measures. You know, Cemre was talking about minimum requirements. So in this case, you know, I think we are looking exactly at the same needs for a certain core measure that can be applied to both public and private ODR platforms, plus standardized disclosure elements, right? And this can be then used by a neutral body, question mark, maybe iCoder, as the body that would certify that the participating platforms in the portal that agree to share their data and their setup would then decide, this neutral body would decide on how do these platforms rank according to these core measures, if they are set up or they are not. Then we would have a satisfaction index here. Cemre was talking about quantitative scale. Again, indexes are really nice and work really well in case you have similar data to compare. Otherwise, if data from one platform has been significantly differently gathered than in another platform, then obviously it would be quite difficult to set up an index such as that. Then, of course, this would refer to rather objective data and user evaluation integrated into the platform. And finally, you know, things like how many cases have been resolved in the past month, in what time, etc., etc., which also brings about the main problem, which is complexity of total accommodation, but we will talk about that later. Then finally, we would have party preferences. In this case, it would be the subjective user evaluation data that would be taken into account. In that, here there would be positive enticements for ODR platforms to design, to tweak their platforms in certain ways or the other, depending on how users respond to the evaluation of the platform after the end-to-end process or between the end-to-end process at different steps. And here we would be talking about things like UX and UI design, aesthetic design, etc., etc. Then that would give the opportunity, also the standardized data processing, gathering, and sharing, to create a sort of marketplace, right? Marketplace or open source, depending on certain core measures that would be made available for ODR designers to take on in modules or designs or outlines. And marketplace in the sense that, you know, certain improvements like the justice spot, for instance, that there could be up there for sale for designers to get it easily implemented into the platform, right? So here I put a couple of examples that we will see later on, like the problem solving wizard or a solution explorer module. But again, for that to work, you need standardized data. And finally, another interesting option would be to have also based integrating all of this with artificial intelligence. It would be great to have an integrated AI wizard for the user that's coming into the evaluation portal to assess his case or the best platform for his particular case. So then there would be a sort of traffic light setup where through an explorer, where the user could assess, you know, which is according also to his own preferences. Once we got all of that data in, which would be the platform that fits the most with his aspirations. And we can talk about both consumers and companies or retailers, especially. Now, for the past months, this is what I've been working up until, just barely this October, because actually I'm working in financial compliance for the Deutsche Börse and interning at the same time. But so hopefully this idea went through of the importance of data and how this could revolutionize the way we do ODR. And then now I would like to center the presentation on a very specific part of it, which would be the side of the certification system of trying how to operationalize all those guidelines, all those ethical standards, all this push, especially here in the European Union, but also by the UN and UNCITRAL, and it's been going on for years. And now it's getting even more pace on implementing reliable and accessible, especially ODR platforms. So what I did, I centered the question on how to operationalize ODR standards with accessibility, right? Because knowing that accessibility is the core fundamental standard for ODR, improving accessibility for vulnerable users is building a more inclusive online dispute resolution systems, which is improving access to justice overall. And then how do you do that? How do you operationalize something like an ethical standard? Well, you can find practical indicators, or so I believed, through observables. So observables through best practices by these same ODR platforms. So what I did is I tried to gather these practical indicators based on both quality sources and guidelines available online and different expert interviews, which I will acknowledge later. And then I set up these tables to summarize each with a short description, and then to which standard, ODR standard or guideline, this practical indicator best aligns with. After that, I compared several ODR platforms which were praised as examples of accessible ODR platforms, and tried to see how, if so, how were these platforms implementing these indicators. So, for instance, I chose some of them for the presentation today to, I guess, grasp an idea of where I'm going. Again, this is not something numerus clausus at all. And, you know, it can be open for discussion later on. But for instance, one thing that's very relevant to vulnerable users is an offline option, having an offline option throughout the end-to-end process. That means before the claim is made, during the process, whatever type it is, if it's mediation, arbitration, or negotiation, and post-resolution, right? Then it has to be responsive to users' request for assistance with the system, but it can also be a way of marking an exception, a soft opt-out for a person to send in the response, a certain response in written text, for instance, or over the phone. Then that's something that throughout the step-by-step guidance that the platform provides, it has to establish, obviously, where is the soft opt-out, where can you actually do this, sort of give an exception by reason of a vulnerability, and where is the hard opt-out, where you cannot exceed on the good faith of the platform just because of purely legal reasons, right? Because of due process or whatnot. Then another partial indicator, which is, as you can see, they are really interrelated between each other. It's a sense of sensitivity training for the operators that will take care of those claims and that will have to take care of vulnerable users. This, just as an anecdote of my testing, sorry, I'm losing a bit my voice here, but within the European Commission's ODR platform for consumers, there are different centers, call centers for user assistance, and they are based in their respective countries. But curiously enough, the 4 countries that I reach out over the phone, pretending perhaps not the greatest example of ethical research, but I pretended that I had a digital illiteracy. And when I called to Ireland, the operator was really unempathetic. Same, more or less, perhaps less unempathetic and more empathetic was the operator in Spain. In Iceland, I felt a bit better. Also, there, both in Iceland and in the Czech Republic, as you can see below, the operator followed some sort of guidelines, but curiously enough, the only department that had guidelines of how to act in case of encountering a vulnerable user. These guidelines were self-made, so these were not provided. And in summary, as you can see, there's a lot of disparity between the different countries. Then we have plain and empathetic wording. We have things like third non-party helper, or just give the option of someone who is close to one of the parties, who's the vulnerable party, who can help. But again, it's important to establish where is the soft out, where is the hard opt-out. A big one, assistive technology. Here we talk about the WCAG 3.0 and the Web3 consortium. We have things like interactive voice response, screen magnifiers, visual reading. This is something more integrated into the UX design. For instance, the e-Toimic platform in Estonia is built and designed to meet these guidelines. For a person with a visual impediment, for instance, or any kind of physical impediment, are really, really useful. Then translation options. We have a user map, or the existence of a user map or a user journey, step-by-step demonstration of how to use practically the platform end-to-end. Many examples, really good examples, such as the CRT or e-Toimic itself. Then a through and through front page, where we must have contact options, accessibility tools, a solution explorer to then start the process, and the user map scenario, and preferably in a click once disposition. Problem solving wizard, we already talked about that. And then again, the importance of data and of including vulnerable users within your data strategy, your data gathering strategy, so that then you can easily twitch and tweak and nudge whatever you want from whatever your platform requires. Now there are many challenges ahead, but I think I'm getting quite late with my time, and it's always hard to be last, but I really want to hear your opinions, and these are my acknowledgements. Many of the doctors and professors and designers that I interviewed are either fellows of the NCTDR or iCoder, or are probably going to be attending this and next forums, because these are amazing people that I had the opportunity to know in person not so long ago in Montreal, beginning of October. And thank you very much. I think that would be my conclusion. And later, I think with Leah, we can, if many of you are students, we can perhaps try and entice you into the new exciting pilot projects.
Wonderful. Thank you, Adria. I do want to thank everyone who's staying on a little bit longer, because there's so much to share, and we really want to celebrate and give space to young professional voices and scholars. So can I just see if we have a question here from anyone? And if you do need to take off, I will put a link in the chat. You can go to icoder.org. If you're interested in becoming a member, it is a branch of it got born out of the National Center for Technology and Dispute Resolution. It's a standard setting organization and a membership organization, and we've created a youth and student membership that Adria was speaking about. So perhaps some of you will be interested in joining if you're not already members. But with that, is there a question for Adria, please? Well, then I'll jump in. I have a question. I know that you wanted to spend even more time talking about challenges. And so I just wonder if you pulled one out and you said you thought that either this is a challenge that you could see being readily addressed, that's on the cusp of getting addressed, that you want to highlight, or one of the bigger challenges that you think really stands out to you. If you could speak to one of them and tell us just a little bit more of your thoughts about that, that would be great.
Right, I think you can hear me. I was trying to put back the challenges, perhaps we can see them. Well, I mean, I guess that again, I'm a firm defender, why not, of the data sharing strategy, right? If you can standardize data, the complexity of total accommodation at least reduces itself to a great extent. If you can standardize it, if you can gather it in a standardized manner, if you can share it in a standardized manner, and if you can assess it in a standardized manner, that should go away. Then another one that's perhaps quite interesting is the erosion of jurisdictional consistency, which is something that, for instance, Dr. Ayelet Sela talks a lot about. And I think also you, Leah, actually, I read a couple of articles. I think that, you know, we are moving on to a new era, right? And especially the young jurists coming up, and the push, the regulatory and policy push from the European Union, at least in Europe, is really pushing for a new way of assessing case of taking off the shoulder the already congested case law from the ordinary jurisdictions in our countries. I think this, this just implies that we need to start to think differently on how we resolve our disputes, even those who until now have been only possible to resolve in front of a physical court. Perhaps it's time to start thinking about e-justice.
Fantastic. Great to get your insight on that. So maybe since we've gone over time, I will thank everyone, stop the recording, and if anyone wants to stay on a little longer to chat, we can certainly do that. But please help me to thank these wonderful scholars for their presentations, and thank all of you for participating.
Thank you so much.